Suppose that,
Oh, go ahead. I don't want to create a bespoke standing rule. However, this case involves the question of injury in a particular context, which is different from other contexts, and that is injury in a competition. So along those lines, let me give you a hypothetical. Suppose that 8 runners qualify for the U.S. finals to go to the Olympics in the 100-meter dash. And when they show up for the competition, they find that actually they're going to have to run 105 meters. Does anybody have, can any of them show injury in fact?
So I think in that circumstance, if this court were, to apply the competitive standing cases, the court would, ask, was, any potential plaintiff as compared to a direct competitor, were they substantially disadvantaged by that? And so, yes, they would need to show some sort of harm.
So they would have to, an individual runner would have to show videotapes of other races and show, I start to lose steam at the 97th meter. So making me go 105 yards is going to hurt me in relation to others?
I mean, I think the standard is one of plausibility, and I don't know that one would need to present that type of evidence to make the assertion plausible.
Are any of them going to be able to challenge this?
I think actually it probably could be fairly easy to challenge if they could.
How would they
could say, I mean, presumably, I could imagine a plausible assertion that, I have, trained for a 100-meter race and a 105-meter race makes some sort of difference that puts me at a substantial disadvantage. But I guess I know the court is resisting going back to the declaration, but standing cases are fact specific.
Well, this is in this specific situation. What would be wrong with a rule that says for competitors in a competition where there's going to be a winner and there's going to be one or more losers, when the rules of competition are changed in a way that produces a risk that can't readily be measured, then all the competitors have standing.
So
doesn't that make sense?
So I don't think that it makes sense to adopt a blanket standing rule for candidates because I think it would create 2 problems. First, it would create chaos for election officials. It is very easy to be a candidate. Any self-declared candidate could challenge any election rule that they happen to have a policy disagreement with, even if that rule were entirely harmless. And election officials who are tasked with actually running elections would have to divert their time and energy and litigate, these policy-based disputes, and then federal courts in turn would be put in the position of resolving these, disputes via advisory opinions, which is exactly what this court's standing cases have dictated should not happen.
Suppose that